Hello, everyone. Nice to see you all again. Thanks for being here with me. So on Tuesday, we got into class actions, right? And class actions, people remember, are this alternative route to justice, which the system has created to deal with situations where the damage done is dispersed among a large group of people, right? And the defendant has done something which is significant and worthy of remedy through the civil litigation system, but that damage is so widely dispersed that it is uneconomical for any individual victim of that wrong to commence a lawsuit themselves. Therefore, class actions let damages be aggregated and let a class of individuals pursue that claim together. There are also, of course, defendant class actions where a single individual wants to sue a group, and it's uneconomical for those individual defendants to defend themselves because of, again, of the value of what is at stake. One of these recently came up with it was like an internet service provider that was suing people who had allegedly breached ISP terms and conditions, or I think there's an intellectual property element to it as well, right? Like copying or stealing music online, that type of thing. So that was a defendant class action. But the lion's share of them are plaintiff class actions, and those are the cases we're looking at. And we also said that class actions, we can think of them, it's not, it doesn't replace the conventional civil action, but rather is two extra procedures which we kind of sandwich around a conventional civil action. First of all, certification, and then settlement approval. And on Tuesday, we were looking at the Hollick case, which is a certification case and remains the leading case from the Supreme Court of Canada about certification procedure. And Hollick is, of course, an application of our Ontario Class Proceedings Act, and in particular an interpretation of Section 5, which are the criteria for when a court should certify a class action. And we went through these. They're fairly obvious, most of them. All of these things must be true before a certification can be granted. We ended off last time talking about the scrutiny of the representative plaintiff, right? That individual who is going to stand up and make decisions on behalf of that class. And Section 5, Sub 1, Sub E tells us what that representative plaintiff has to establish before that class action can be certified. And Mr. Hollick had no problems with that. He's got all of these worked out. Mr. Hollick also demonstrated that there are common issues, right? So the Supreme Court says at paragraph 19, there is no doubt that if each of the class members has a claim against the respondent, some aspect of the issue of liability is common within the meaning of Section 5, Sub 1, Sub C, right? So of all these people in this square on the map who are close to the Keel Valley landfill, to the extent that they have valid claims against the Keel Valley landfill, they will have something in common, right? There's a common element to their claims. They're all going to have to prove this landfill exists, that this much garbage goes through it, that the nature of the garbage is X, Y, and Z, right? So there might be things that distinguish their claims, and we already know that the Class Proceeding Act welcomes class actions in which there are differentiating factors. This is certainly not supposed to be an act which only works for people who all have exactly the same damage. But there just has to be something which all those claims have in common, which renders it economical to pursue the matters through class action. Okay, so Mr. Hollick passes that. However, the Supreme Court in Hollick does something which many people found unexpected, and many people found kind of odd, maybe a little bit pushy when it comes to statutory interpretation, because they add a couple of requirements that are not to be found in the language of the text. So one of these is this rational relationship business, right? So they say that not only does there have to be an identifiable class, but there has to be a rational relationship between the class and the nature of the suit, which basically means that that class can't be too large. So here are the key paragraphs establishing this, right? They say it's implicit in the identifiable class requirement that there be some rational relationship between the class and the common issues, and the class can't be too large, not unnecessarily broad. The plaintiff did not pass up an opportunity to define that class more narrowly without excluding some people who share the same interest in the resolution of the common issue. And you know, as an example, if you were bringing a class action against Loblaws, and the problem that you're suing over is, you know, there was some sort of E. coli bacterial infection in the spinach that was sold in, you know, Loblaws stores in the Greater Toronto area. But then your class action documents go out and define the class as everyone who's shopped at Loblaws, you know, anywhere in the country over the past 2 years, right? Way too broad. And the court's saying that, you know, by the plain language of the Class Proceedings Act, there's nothing that says that we have to, you know, exclude all those people, but they want us to interpret this such that we can't have a class which is too large. It can't be arbitrarily large. And if the plaintiff should have left some people out, drawn that boundary more narrowly, then the court's going to require them to do so. Okay, and the onus there is on the class representative, that is to say the representative plaintiff. In paragraph 22, they have to have evidence supporting this proposed class. Okay, so far so good. Hollick has managed to do that. Where he trips up, and the reason why his class action is not in fact certified, comes under 5 sub 1 sub D, right? The preferable procedure for the common issues. And the court says at paragraph 27 that this preferability inquiry should be conducted, is a little bit more complicated than the statute might make it seem, right? So the statute just says that it has to be the preferable procedure for the common issues. So it doesn't have to be, the statute says that, you know, if there's 4 non-common issues and 1 common issue, that is to say, if there's only one small thing that connects all of these, right, and the rest of the claims that the class members have are different, then the Act suggests that the preferability inquiry is only conducted with regard to the common aspect of the claim. The Supreme Court interprets that in a very different way. They say that it's not just about the common issues. It would be impossible to determine whether the class action is preferable in the sense of being a fair, efficient, and manageable method of advancing the claim without looking at the common issues in their context. So the question of preferability must take into account the importance of the common issues in relation to the claims as a whole, right? So this is kind of a subtle distinction, but on a plain reading of the Act, it seems like we just focus on the common issues. We just focus on what all the class members have in common, and we ask about preferability with regard to that. The Supreme Court of Canada says, no, we're also looking at how extensive the common issues are relative to the entirety of their claims. So if what they have in common is too small relative to the things that distinguish those class members' claims from each other, then class action is not going to be preferable. So hopefully people get that. And preferability, whenever you hear the word preferability, you know that you have to do some kind of comparison. And here the comparison is between class action and all the other things that these people might do to advance their claims. Again, not getting at the merits here, right? So none of this is about whether there actually was pollution coming from this dump, whether these people suffered any losses, whether there's some statutory defense which immunizes the Keel Valley landfill from the claim. None of those substantive issues are at stake when we're talking about certification. We're simply talking about the procedure, whether this procedure compared to the alternatives is a good one. Paragraph 28, they give us a few alternatives, right? So what is it that we're going to compare class actions to? And some of these are kind of old ideas we don't really need to know about. So they talk about consolidation. Did I give you them wrong? Or they talk about consolidation? Oh yeah, here we go. So in the sense of preferable to joinder, test cases, consolidation, and so on. So joinder and consolidation are kind of obsolete, but what's a test case? Can anyone tell us what a test case is, and perhaps how it might serve? It might be an alternative to a class proceeding. Okay, so test a new legal issue. That's a good start. Anyone expand on that, and maybe tell us how this is something that could do some of the things that class action does? So if Mr. Hollick were to bring a test case, he would be acting alone, right? He would be starting a conventional civil action. And we wouldn't call it a test case unless it were trying to establish some new law, right? So let's say no one has ever sued a dump before for pollution, and Mr. Hollick goes ahead and does so using the conventional civil action. And that's a test case. In what way might that serve some of the same policy goals that class proceedings? Yes, that's exactly right. It helps establish a precedent. So Hollick sues, he'd be in small claims court because his individual damages are small. But if there's a judgment, then all of a sudden it becomes easier for all of his neighbors to do the same thing, right? And so in that sense, a test case is an alternative, and one of the things that we need to compare the class action procedure to when we're trying to decide whether or not it's preferable. And of course, that inquiry into preferability is what is required by section sub 5, sub 1, sub D. Okay. So the court tells us, paragraph 29 to 30, that despite the fairly plain direction of the statute to preferability for common issues, actually we need to think about preferability for the claims in their entirety. So this this was controversial, right? I mean, we know that the Supreme Court of Canada can overrule and read things into statutes when there's a constitutional argument to be made. The Parliament and the legislatures cannot create unconstitutional laws, and if they do so, the Supreme Court can strike them down. But here, there's no constitutional argument, right? And many people said, well, look, in the absence of any constitutional argument, the legislature is supreme. And the legislature chose to decide, chose to have the preferability inquiry pertain only to resolution of the common issues. They had a law reform report where they focused on that issue, right? But whether it's preferability as a whole or just preferability of the common issues. And this isn't just like a semantic difference, right? This is actually really important, because what the Supreme Court of Canada did here is make it significantly easier for defendants to resist certification. Because now, from the way the statute is drafted, it sounds like the plaintiffs can get certified if they can just show that there's something that all these people have in common, and with regard to that little something, class action is the best procedure. Now they have to show that class action is the best procedure for the entirety of those claims, right? So defendants love Hollick because it helps them resist certification, and as we know, certification is a hugely important question, because once certification is granted, the plaintiffs have a huge advantage. The Keel Valley landfill has nothing to worry about if this is not certified, because realistically, very few, if any, of these people are going to bring any type of litigation against the Keel Valley landfill. So that's why this was kind of controversial. Okay, so we come back now to the facts. And they're going to apply this this understanding of the law to the facts, and that starts at paragraph 32. And they say that we're going to we had to do this inquiry about preferability while paying attention to the policy goals of class actions, right? So we need to think about the reasons why we have class actions in the first place in order to decide whether the class action would be preferable for a particular dispute. Judicial economy, serve judicial economy by avoiding unnecessary duplication and fact-finding legal analysis. Improve access to justice by making economical the prosecution of claims that any one class member would find too costly to prosecute. And third, ensure that actual and potential wrongdoers modify their behavior to take full account of the harm they're causing. Okay, so they scrutinized Hollick with all these things in mind. In terms of judicial economy, Hollick kind of fails, as they say the common issues here are negligible relative to the individual issues. So even if we certified a class action on their common issues, then we'd still have to have individualized determinations of, for example, how much exactly did Mrs. Jones at 4 Poplar Plains Crescent, how much damage did she experience from the dump, right? And how much damage did that guy down the street experience? And they'll all, because wind patterns blow in different directions and they have different exposure and their houses face in different ways, each one of those victims is going to have their damages assessed individually. So the Supreme Court of Canada said, we're not saving much in the way of time, and we're not saving many judicial resources by having a class adjudication of the common issues. They also say, at paragraph 33, that there's a specific alternative which is open to these class members that defeats Hollick. That's really important, right? They refer to the Small Claims Trust Fund. I don't know if anyone caught what this is. They kind of sneak it in. But the Small Claims Trust Fund is something that was established by the provincial government when they created the Keel Valley landfill. And what it is the Ministry of Environment has this sum of money, and if anyone complains about the dump and can show without having to go to court that they've suffered some damage as a result of the dump, they can get up to $5,000 resulting from that. Right? So this is a special dispute resolution fund established in the Ministry of the Environment to deal with what's described as off-site impacts from a dump. And that is a highly accessible procedure by which people with claims of less than $5,000 can get reimbursed. We don't know the details, but probably they just have to show damages in this kind of an informal way. They don't have to establish any liabilities, so it's quick and it's easy. And it's funded by the ministry, but it's being administered by a third party who is sort of neutral with regard to these claims. So the Supreme Court says, okay, so of all these people living in this neighborhood who they have damages less than $5,000, they've got this Small Claims Trust Fund they can use. And if they have damages worth more than $5,000, then the access to justice argument doesn't work so well for them. Right? Because if it's worth more than $5,000, it's thought to be economical to pursue that in small claims court. Right? It would be small claims court procedure would be proportionate if your damages are really worth more than $5,000. Right? And this is back in 2001, so $5,000 was worth a little bit more than it is now. Okay, so paragraph 33, they also say this small claims trust fund, right? It's like it comes out of nowhere, and it defeats Hollick in a really unexpected way, because they say that the fact that no claims have been made against the small claims trust fund may suggest that the class members' claims are either are either so small as to be non-existent or so large as to provide sufficient incentive for individual action. So this is I said at the beginning of the course that civil procedure is mandatory because it's supposed to be of assistance to all of you in your legal careers, even if you do not become civil litigators. So some of you may go into transactional work, right? Some of you may become the sort of lawyers who draft the documents by which entities like the Keel Valley landfill are established, right? I mean, nothing gets created, nothing of any size in our society gets created without lawyers drafting the contracts and advising the parties about the risks that arise from what they're doing. So I think it may well be true that some clever lawyer who took civil procedure was representing the Ministry of the Environment when they were creating this Keel Valley landfill and said, look, let's put in something like this small claims trust fund, because not only will this, do the right thing and help people who are affected by it without making them go to court, but it also protects us against risk. And in this case, it actually protected the Keel Valley landfill from the risk arising from the risk of a certified class action. And the $100,000 they spent to create the small claims trust fund is peanuts compared to what they would have had to pay to settle this had it been certified as a class action. Right? Class actions are a nightmare for defendants. They hate it, and they fight tooth and nail on certification. And not just because they're stingy and don't want to really help people, but also because once a class action against you is certified, you have big legal fees of your own, and you're going to be paying a whole lot of money to lawyers for the class, right? To class counsel, as we call them. Who are going to be getting often 7-figure legal fees from the certification of a class action. So if you're drafting documents, if you're in a transactional practice, try to think a little bit about civil procedure, because civil procedure is a risk for your client, and it's a risk that you can mitigate, if not eliminate entirely, through foresight and through clever drafting. Okay. So, I should say, by the way, we have Canada's leading expert on class actions at the Faculty of Law, Professor Kalachik, who recently wrote a major report for the Law Commission of Ontario about class action law going forward. Anyone taking her class right now or taking it next term? I think a couple people in the course are. Hopefully I'm not contradicting anything she said. Okay. So I'd recommend that course if this stuff is of interest to you. Okay, so why defendants like Hollick? So defendants like Hollick because the Class Proceedings Act seems to sort of a plain reading of Section 5 sub 1 sub D says that we're going to certify, assuming the other requirements are met, we're going to certify so long as a class proceeding is preferable for the resolution of the common issues. Meaning that if the class members, so each class member, that's why I don't know if this is helpful, but I use this kind of DNA slide, right? You can think of like each of these, if this is helpful, you can think of each of these strands of DNA as representing the claim of each of those members in the proposed class. Right, and they're very different. So whether we've talked about Hollick, or if it's the beer store class action, then someone who buys a 2-4 every week has suffered more damages than someone who just buys 6er every week, and someone who goes to the pub and pays inflated prices at the pub has a different claim than someone who buys the beer at the LCBO. But the idea is that despite all the things that distinguish them, if you're making a class action, you're just saying there's some common element that unites everyone in that class. And the Act seems to say that we're only asking about, we can certify so long as a class proceeding would be preferable to resolve that common claim. The Supreme Court of Canada says, no, we're actually going to say, we're going to ask whether a class proceeding would be preferable with regard to the entirety of the thing, the entirety of the claims of the class members. Therefore, the court says, if the common issue that's being alleged is too small relative to the claims, that there's too many other things that they don't have in common, then that can make the class proceeding unpreferable and doom that certification motion. Okay, so Daniel asks, so this small claims trust fund, this is just about this dump, right? The small claims trust fund is not a thing that exists for people generally. Small claims court does. The small claims trust fund was established by the Ministry of the Environment for the people who live in a certain area and have a claim, have alleged damages arising from this particular dump. So it doesn't affect people. It's not relevant to, and you don't need to know about it for class actions generally. Okay, so the participation questions. Okay, so this is a bit of a trick question. According to the Class Proceedings Act, what is the minimum number of people required to start a plaintiff's class action lawsuit? Many people said 2, and I can see why you would have said 2, because a class action under section 5, sub 1, sub B says there has to be an identifiable class of 2 or more persons that would be represented by the representative plaintiff or defendant. However, section 2 sub 1 says the 1 or more members of a class may commence a proceeding. So 1 is the answer I was looking for. Because the way this works, and we saw this with the Hughes beer store class action and Hollick, 1 person is the representative plaintiff, and they start the lawsuit, and it's their name on the statement of claim, and they have to identify a class of other people. But those other people, those class members, usually have nothing to do with it, and they don't know about it, even at the beginning. So it just takes 1 to start it, but you have to define a class of 2 or more. Which one of the following would be most likely to receive certification under the Class Proceedings Act? So here I was looking for people to basically apply Section 5 and Section 6. So how about this one? Why does this one die? Bingo, conflict of interest, right? How can we possibly trust this person to sue the beer store when he's married to the spouse, or married to the CEO? Okay, 20 people have claims against the provincial government. Some of them slipped and fell on inadequately salted steps outside the Ministry of Transportation office. Others claim for damages for wrongful imprisonment. Okay, so this sounds pretty good because they're all suing the same defendant, and there's no evidence of conflict of interest or anything like that. But that's right, they don't have a common issue. So there's no, just having a single defendant is not good enough. There has to be something that unites all their claims that makes it sensible to use a class proceeding to resolve it. So here we have a common issue, right? We've got, they've all suffered the same wrong, but what's wrong here? That's right. So there's a jurisdictional question. So the Class Proceedings Act is an Ontario statute. It does not apply to a lawsuit against the government of Saskatchewan. If you take class proceedings with Professor Kalachik, you'll get into multi-jurisdictional class proceedings and how what we're trying to do to make these things work across the provinces despite provincial jurisdiction, but it wouldn't work here. And the other thing is it's not preferable because there's different defendants, right? So it wouldn't even be one lawsuit; it would be multiple lawsuits, and that's not identified as an issue in Section 5 and Section 6, but it's sort of is inherent in the nature of a civil action, right? You're suing a single defendant, or multiple defendants who have, have violated the rights of the same plaintiffs, right? Here it's different defendants with different plaintiffs, so that cannot be a action suit. And that leaves us with this one, right, which is correct, as most people got. It doesn't, even though we don't know how many people it is, and their damages vary widely, they have a common defendant. They all have a common issue in the sense they'll all be sort of making the same arguments about the contracts or about Telecommunications Act or something, but you can see how the legally common issues would be there. This one was a callback to our mandatory mediation material, and it was just picking up the fact that mandatory mediation happens quickly after the statement of defense. So statement of claim first, then statement of defense, then this, and then this, and then this. All right. Mandatory mediation third, that's correct. So Hollick went down to defeat, was not certified. The same is true of the beer store class action. Also did not go down. Also did not end up succeeding. But many class actions. Yeah, I'll get to the remaining questions in a minute when we get to that material. So many of these class actions do continue, right, and are proceeding as we go, and we are all class members, right, without even knowing about it and without being told about it. We are class members of many ongoing class actions, generally pertaining to consumer issues, but some about other things as well. We basically go along for the ride until you get to the settlement stage, right? So this is the third part of a class action, right? After certification, the parties will go through all the normal steps of a conventional civil action. Some of them don't settle. If they don't settle, then they have a trial and possible appeal and enforcement and so on. Most of them do settle, but they cannot settle without being approved by the court, right? So this is the other thing that distinguishes this from conventional civil actions. As we know, in a conventional civil action, no settlement approval is necessary. If the parties decide that they want to settle, then they enter a settlement contract, which can be an oral settlement contract or can be on one of those forms, and then it's settled. And the only thing they would have to do is enforce it, assuming they can't, they don't voluntarily abide by that contract. The court has nothing to do with it. But here we have Section 29 of the Class Proceedings Act. It states that a proceeding commenced under this Act and certified as a class proceeding under this Act may be discontinued or abandoned only with the approval of the court. So discontinued or abandoned, right? That means settled. Well, it can mean settled. I mean, an action can be discontinued in the sense that the plaintiff just drops it, but without getting anything in exchange from the defendant. But as we know from our material on discontinuance and withdrawal, you have to either drop it unilaterally early enough, or get the defendant's permission to drop it, or get the court's permission to drop it in the normal case. But here, no action can be discontinued or withdrawn without the court's approval. And no settlement is binding unless approved by a court if it pertains to a class action. So why do you think this is here? I mean, the system encourages it. Why wouldn't we let in class actions, we we always have represented parties, right? There's a lawyer for the class and there's a lawyer for the defendant. So if they want to settle it, why not let them? Why this extra scrutiny? The class members are not fully represented. Okay, to ensure fair negotiations. I mean, fair negotiations with represented parties, we generally assume that the lawyer is going to do that, right? We don't scrutinize it. But there is something about the representation of the class members.
Hi, can you hear me?
I can.
Is it because the class members are represented by the representative plaintiff, if they settle, then the issue is adjudicated on its merits, like it's finished, and so the class members have no longer any recourse to go after the defendant at that point, right? I think.
That would typically be the case. So the defendant in the settlement agreement would require a release, basically releasing the defendant from any future claims about the same stuff. So yes, that's quite right. So the class members are giving something up, and we're not at the table, right? We don't know what's going on. The representative plaintiff is supposed to be there for us and protecting our interests, and there's some measures in the Class Proceedings Act. We have this conflict of interest test to make sure there's no overt conflict of interest going to prevent them from doing so. But still, the assumption is that they may not be entirely loyal to us. And there's also a risk to class members that comes from the question of compensation and the fees of class counsel. Yeah, so make sure the compensation is fair. So it's not quite accurate to say that all members of the class are given equal compensation, right? Because very often there will be the settlement mechanism and the payout mechanism will have a way to give more to some class members if they have suffered more damages than other class members. But the lawyers' fees are pretty important, because the thing you need to understand, the real politique of these class actions is that they're basically invented by law firms, right? By class action law firms. We refer to class actions as a very entrepreneurial area of law, because the reality is that plaintiff side class action firms employ people whose job it is to basically read the news and look for potential claims. So if, for example, they're always monitoring any news stories about food poisoning, right? If people get bad spinach from Loblaws and there's an E. coli infection, then all the plaintiff side class action law firms will sort of race to start a lawsuit about that, start a class action lawsuit about that. And the representative plaintiff is someone who they recruit, right? Class actions do not start with someone, with a person who suffered a loss walking into a plaintiff side firm and saying, I want to start this suit. They start with the firm finding the problem, finding the potential suit, and then recruiting the representative plaintiff and going off to the races. And it's they do that because it's potentially very lucrative, right? As we'll see when we get to Cassano, these the very highest earning lawyers in Canada are class action lawyers, because these things can generate huge fees. So the reality is that you'll often have class members who really don't care much, because it's like a very small amount of money that each of them has at stake. The representative plaintiff may not care very much either. The firm does care. And the settlement, among other things, is going to specify what their fees are going to be. And if there were no court approval, if there were no sort of neutral adjudicative body going over that settlement, then it would tend to be only the firms that benefit. They would tend to get very, very large fees. Because the defendant, right, the corporate or government defendant, which is agreeing to the settlement, doesn't care about the plaintiff's lawyer's fees, right? They just care about their total exposure. So the idea is that the system of representative plaintiff, to say the least, is not fully functional in ensuring that the interests of class members are protected. Therefore, we need courts to scrutinize those settlements to make sure that that the plaintiff's side firm is not giving up too much, and also to make sure that those lawyers are not enriching themselves too much from money which would otherwise be distributed to class members. Okay, so Christopher asks a question about what happens when firms start class actions for the same issue. This is called a carriage battle, and this does happen. It's a theme, I'm sure, in Professor Kalichik's course. We don't have time to get into it, but basically a court will have to adjudicate that and decide which of those firms would better represent the class. Okay, so this brings us to the Cassano case, which illustrates some of these dynamics. So Dr. Cassano has a Toronto Dominion credit card, TD Bank credit card, a normal Canadian dollar denominated TD credit card. And he takes his Visa card on a weekend trip to New York City. He pays for a hotel, which is charged in American dollars. So far, so good. Sounds like a nice weekend. What's the problem? What's the beef? The surcharge. You got charged a fee because, okay, this is good. We're getting kind of a word cloud here of associations. Foreign currency transaction. Yes. Okay. I think we've now got enough particles in the cloud to get the answer, right? He says he was charged way too much to buy these American dollars, right? The foreign currency transaction was way overpriced. He figures out the exchange rate, like the market exchange rate on American dollars on that day, and if he would have got much more in American dollars if he paid in cash. So he claims he's been ripped off by the credit card company. Now, the bank's defense, the bank has a defense. They say these were not fees, these are not extra fees we didn't tell you about, but rather part of the exchange rates that we, the bank, were authorized to charge by the provisions of the cardholder agreements to determine from time to time. So you know these. You know, every time you get a credit card, you get a little slip of paper with the agreements, and I'm sure we all read those and take note of every provision that we're agreeing to. But they say it was all there. So it's a contract dispute, right? Simple contract dispute. They say it was disclosed. He says it wasn't. Okay. There he is with his credit card bill, and he sues Dr. Cassano not just on his own accord, but on behalf of this class. And who would the class members be in this case? If you were writing up the statement of claim, and you have to satisfy the Class Proceedings Act and delineate the class, how would you define the appropriate class for this? So it's not just all TD customers or all TD Visa card holders, but those who use foreign currency, and probably it would be all foreign currency, and not necessarily just the American ones, right? If you're the firm drawing this up, then you want to define the class as broadly as possible to maximize the damages that you're going to be able to claim. Okay, and again, some of you were probably in this class if you happen to have a Visa card at the time, this particular Visa card, and have done foreign currency transactions. So there was, as always, well, not as always, but as often, a very intense fight over certification, including appeals of the certification motion. But once certification was granted, the settlement followed fairly quickly, right? And this again is typical, right? Whether the claim has substantive merit is often less important than whether or not the plaintiffs will have the advantage of proceeding as a class or not. And once they were granted that, the defendant came to the table with a fairly large settlement offer pretty quickly, as we'll see. Okay. Right. Paragraph 6. So this was a hot case. Paragraph 6, the bank has settled this, but they have not resiled from its position that the alleged charges were disclosed to cardholders. So they accepted the settlement offer, but they still say we have not done anything wrong. We're just settling this to avoid risk and to avoid the trial. So this interest is an example of the flexibility of settlement in civil litigation, right? Because if you want to settle a criminal dispute, if you want to take a plea bargain, then you have to admit your guilt. But in civil litigation, if you're the defendant, you don't have to admit that you did anything wrong. You can sign a contract with the plaintiff saying, we're settling this, but we still say we did nothing wrong. And defendants sometimes find that quite valuable. So they've got this money. They put the money on the table, and the court pretty quickly approves this settlement for $55 million. Right? So the court says, well, you know, they asked for a lot more in the statement of claim, but it was reasonable for the plaintiffs to accept less, given that they had the risk of losing and getting nothing at all if they went to trial. So basically, it was a reasonable decision on behalf of those class members for them to settle this for $55 million. Okay, so the court has to approve this settlement. And this puts the courts in an unusual position, right? Because usually judges in civil litigation are adjudicating disputes between the parties, right, according to the law. Here, the parties are on the same page. They both want to settle this for $55 million and divide the money in a certain way. So the court, it's an unusual thing for the court to do. But Section 29 of the Class Proceedings Act requires them to do so. At paragraph 4 of the judgment, they review some of the basic principles to be used on the settlement approval applications. There's a presumption of fairness for the agreed settlement. So we start with the assumption that it's fair, but we scrutinize it to see if it's not. They talk about some of the factors, right? The likelihood of success, the degree of discovery, the terms of the settlement. And all of this is about saying, was it reasonable for the plaintiff to accept this deal given the risks and potential rewards of continuing on with litigation? Section 29, the settlement approval business, is about the amount, so the $55 million in this case, but also about what exactly we're going to do with the money. And that's the problem in this case, right? What is it about this class and this particular this money that makes distribution of the settlement difficult? Very often there's no problem, but there's something about this case and these facts that make it tough to distribute these settlement funds. Why can't we just take this $55 million? Because the first effort will always be to take that money that's covered in the settlement and just distribute it, equally or according to damages. Okay, so people spent different amounts. Yeah, every individual may need to show proof of their own loss, right? That's often the case. So the lawyer's fees, we'll get to that. That's another issue. The currency rate is in consonance to assessing damages. Yes, that could also be true, as Sarah says. So it's kind of it's not a fixed target, right? The currency exchange rate changed over time, and so if so damage that each card member had will vary. It comes down to these all these different problems of distribution, right? The class is very large, for one thing. So here at paragraph 10, we hear that there are 10 million people, several million people in the class whose transactions were entered into over a period of many years. And it's not all, like, it's easy for the defendant to produce a list of all their cardholders, but it's not all cardholders, of course, in the class, right? It's only those who actually paid these foreign currency charges. And at paragraph 12, the bank, their evidence is that it would take 1,500 people about 1 year to identify and record the foreign exchange transactions on the cardholder statements that are available only on microfiche. People even know what microfiche is. Anyone heard of microfiche anymore? So yeah, microfiche. The veterans will recall. Yeah, it's like it's used for like newspapers from the 19th century. It's like they're on these little what's the word? It's like little like film things, and there's like a complicated reader, and you have to thread this thing in and read it, right? You'll find it in reference libraries. So, talk about space age bank technology, right? They don't have a database that can output this. It's all on this basically analog paper-like format. So someone would have to like manually go over all of them and highlight and then correlate all the ones that were foreign currency transactions. And just doing so, just figure out who the class members are and how much they have each lost would cost $48,500,000, right? And it's only $55 million that they've agreed to pay. So it would be grossly disproportionate to undertake the effort to actually apportion the settlement appropriately. So where does that leave us? We've got this $55 million settlement that the defense agreed to pay. The court says the amount is okay. But what the heck are we going to do with this big old pile of money, given that we cannot cost effectively send it to the people to whom it's actually owed, right? Which is to say the victims of this foreign currency overcharging. May we all have such problems, right? So don't worry. I mean, the lawyers for the plaintiffs say, well, don't worry about 10 or 15 million of that because we'll just keep that ourselves. We have to, the plaintiffs' lawyers have to be paid. But what about the remainder? And in principle, it belongs to these class members, right? That's the whole point of class actions, is to get money for class members when they can't otherwise pursue their claims. Okay, so what do they propose to do with the money? So paragraph 15 is they get into the details here, right? We're going to assume there's 39 million left over after the lawyers get paid. 10 million would be paid directly to cardholders whose cards were issued before certain dates included in the class definition and who are in good standing and active as of June 1st, 2009. So bear in mind, this is not the same as the class members. The class members are those who paid foreign currency transactions, and in principle, they should be getting different amounts based on how badly they were hosed by these excessive transaction fees. Here they're saying, well, we can't figure out who those people are, so we're just going to divide the money among everyone, even those who never left Canada, who had the TD visa card during this period. Okay, that leaves us 28.4 million, and we're going to apply it C-press because the parties are in agreement to do so. Okay, so what does this mean? This is a French word, right? Which basically means so near as, or so close, or as near as possible, right? So a C-press order means an order which pays the money to a group as near as possible to the people who are actually supposed to get the money. The idea actually was borrowed from estates law, because if I write in my will that I want to leave half my money to the Royal Society for the Prevention of Cruelty to Octopuses, and then I kick the bucket, and my executor finds that there is no such thing as the Royal Society for the Prevention of Cruelty to Octopuses, what are they supposed to do? So one response would be, that money should stay in the estate or go to the other beneficiaries. But as David suggests, the actual thing we do is we try to give that money to something which is as close as possible to the thing I mentioned, right? So if there's some other group protecting the octopuses, we might give it to them. Or if we can't find any charity out there that works for the octopuses, the squids are going to get it. And that's going to be as near as possible to the intention of the testator. Okay, so that idea was imported from estate law into class proceedings law. And the idea is we're going to do with this 39 million something as close as possible to what we'd really like to do with it. Okay, so at this point, it's kind of open season for everyone in court, the lawyers for the defendants, the lawyers for the plaintiffs, and the judge himself to kind of spitball their ideas about, what should happen with this big pile of money. The Toronto Dominion Bank's idea is financial literacy, this financial literacy initiative, the TD Financial Literacy Fund, right? So bear in mind these are the defendants, right? And this is money they've agreed to pay to end this litigation. And they say we want this money to go to be used on workshops and internet videos, and we'll go to classrooms and hire people to tell kids about be responsible with your money and always read your cardholder agreement and yada yada yada. And the thing about this is that it also happens to work pretty well as PR for the bank. Because they get to put their name on something which creates warm, fuzzy feelings, and it looks like they're educating the youth. A student actually once told me that she worked for this TD Financial Literacy Fund that was created by this class action settlement. And even as an employee of this organization, she never knew where the money came from, right? So no one knew that the money was money that TD Bank had to pay to honor this settlement, and had to pay because of their liability over, regarding undisclosed foreign currency transaction charges. It just seemed like some great thing that TD Bank was doing out of the goodness of their heart to, bring the youth up to speed on financial literacy. Okay, so that's their idea. The plaintiffs have another idea of what to do with 39 million. They say there's this idea of giving it to, this was actually a brilliant idea, give it to law professors to do research. So that was a beaut. That also didn't end up flying. That was thought to be a little bit too obviously elitist. And here it is, plaintiffs give grants to Canadian common law schools used to foster professionalism and ethical conduct among practicing lawyers. So I would have voted for that one. We could have given it to the law students. But this, the judge doesn't like this, right? He says, without, I hope, being unduly cynical about the optics of the plaintiff's proposal, I suggested a preferable alternative would be to create a trust fund to be administered by the Law Foundation of Ontario, which is this nonprofit that funds access to justice stuff, for the purpose of advancing public access to justice in Canada. Which is actually what happened, right? The LFO ended up getting a big chunk of the money. So you can see that on our web page. I asked them for some of the money to do my own access to justice research. They never gave me any of the money, even though I asked nicely. But maybe you can ask for some of it too. Anyway, they all basically get their own chunk, right? And everyone is made happy because $39 million goes a long way when it's just going to be divided among these different pet causes, which these lawyers and judges happen to be a fan of. Of course, the class members, maybe by necessity, or maybe there's a more cynical way to look at this, but people who actually had TD Visa credit cards, who were the whole reason why this class action happened, only got 10 million out of the 55. Okay, so that's the question, what to do with the big chunk of money. And then the other live issue here is fees of class counsel. So class counsel is the phrase we use for lawyers for the plaintiff class. And this is often a big sticking point when it comes to settlement approval, because the settlement negotiation process doesn't really necessarily get us to a fair number, because the settlement negotiation is done between the lawyers for the defendant and lawyers for the plaintiff. The lawyers for the defendant don't care how the money is divided, typically, right? They want to minimize their exposure, and if they approve, if the defendant's lawyer, is simply looking at the bottom line and they say, okay, we'll approve $55 million, and you lawyers can take 30 million, or we'll approve $60 million, and you lawyers only get 15 million. They're going to go with the 55 million, right? They have no skin in the game when it comes to how the money is divided. And of course, the plaintiff's class counsel are not in a position to fairly decide how much they should be allowed to take. Hence the necessity for approval of the settlement. So there's a potential conflict of interest. We've talked about conflicts of interest and representative plaintiffs. Does anyone catch in this case the conflict of interest, potential conflict of interest that exists on the plaintiff's side? So paragraph 58. No, not necessarily the card holders, because the card holders are not here. They're not present in any of this, right? The class members are typically just along for the ride, and they don't have any input into this, as we'll see with the next piece. But there's something regarding the representative plaintiff. So paragraph 58, Dr. Cassano is the spouse of Ms. Pat Spate, who is a non-equity partner in a firm of Sutz Strasbourg, who act as co-counsel for the plaintiffs. Okay, so Sutz Strasbourg is a firm right here in Windsor. It's one of the leading plaintiff side class action firms in Canada. And Dr. Cassano is her husband. So, I said at the beginning that this case got started, or it sounds from the judgment like the case got started when poor Dr. Cassano went on his weekend trip to New York, got overcharged and hit the roof. It's quite possible that what actually happened is Sutz Strasbourg came up with the idea of having this case, and maybe Patricia Spate came up with the idea of having this case, and she recruited her husband to go out and take this trip and suffer the loss so that he can be the representative plaintiff. And because, as I say, these things are typically cooked up by the firms, and the representative plaintiffs are recruited. So why does this conflict of interest matter? Why do we, as class members, because many of us were class members in this class, why might we be angry or suspicious or upset about the fact that the representative plaintiff is married to the lawyer? We could possibly get a better deal. Yeah, a better deal in what way? How could we get a better deal if we had someone who is truly at arm's length from the firm that's representing us? Okay, so there is an issue of bias, but why does that bias matter? Higher lawyer fees, more money, or an admission of guilt. So when it comes to getting money from TD Bank, we don't really have to be worried, right? Because Patricia Spate and Dr. Cassano and all of us class members are on the same page. We all want as much money as possible from TD Bank. But Rhiannon has got something really important here: the lawyer fees, right? The representative plaintiff is the client who negotiates with the firm, right? So in principle, the representative plaintiff selects the law firm which will best advance our interests. And in principle, the representative plaintiff negotiates a retainer contract with the law firm which keeps the fees as low as possible. Because the lower the fees are, the more money there is left for us, the poor schmucks who actually got hosed by TD Bank, right? And if this guy is married to the firm, it's ludicrous to think that he's shopping around for the best possible firm to represent us and driving a hard bargain when it comes to what their fees are going to be. So this struck me as a problem. What did the court say? They say this bears will call for close examination and perhaps suspicion. It was, however, disclosed at the hearing of the certification motion. And again at the fairness hearing. So there's the certification hearing we already know about. The fairness hearing we don't have to get into the details, but basically, this was in the pleadings. This was acknowledged in the pleadings, and the court signed off on it. So I don't know if that satisfies you. It doesn't actually satisfy me. I don't think anyone should be in a position to represent a class as representative plaintiff when they are have such an overt conflict of interest. But anyway, the court says it's okay, and we're off to the races. So 11 million is what was agreed to, right, in terms of the fee for the firm. That is 5.5 times counsel's approved time, right? So even though class counsel firms operate on a contingency basis, they will also docket their time, and they will also have official hourly billable rates, just like time billing lawyers always do. And so if you add up all the hours they spent, then and multiply it by their hourly rates of the lawyers in Strasbourg who did the work, then you get about 2 million. 11 million is 5.5 times that approved time. So why are we giving them more? What's their basic claim for getting more than what they actually docketed? 5.5 times more than what they docketed. That's right. So a contingency fee. A contingency fee is one in which the amount payable to the firm or the lawyer hinges in some way on the success achieved in the case. So if they got nothing, then they would have zero fee, and if they got much less, then they would have had a much lower fee. So here the idea is that since they succeeded, they need to get this multiple. So many contingency fees are done on a percentage basis. This one is not done on a percentage basis. It's still contingency, but it's more of this multiplier business where we're going to multiply the docketed time by a multiplier which reflects the degree of success in the case. So they talk about the law regarding fees, right? We start with the retainer. The retainer almost always says it's going to be a contingency basis, there's been some empirical research done on what percentage usually gets paid. It's generally about 22% of the settlement value ends up being the fee for the in-class counsel, in-class actions for the plaintiff's firm, with an average multiplier of about 1.95, so generally about 2 times what they actually docketed. The lawyers want 11 million. That was what the contingency fee retainer said. They say it was communicated to numerous class members. So what this means, it was communicated to numerous class members, means that they would have sent letters to all of the people who had TD Visa cards at the time, saying this is what's going on, this is what the retainer agreement says. Only one member out of a class of several million persons had objected to the size of the fee. And this isn't really a surprise, right? Because you may have gotten these letters before or received emails or seen notices in the newspaper about class actions that you might be a member of. It's very seldom in your interest. Very seldom do you have enough at stake as a class member to take any interest in what's happening, let alone take some steps to challenge the fee that's being charged, which is why we have court approval. But anyway, no one protested, and they were so that weighs in the firm's favor. They say it was all or nothing, hard fought all or nothing litigation, right? They could have gone to trial, and it's all or nothing in the sense that because it's a contract dispute, a court could have said, the cardholder agreement disclosed this. The language was reasonably clear, therefore there was no breach of a contract, therefore TD Bank owes nothing, therefore the law firm gets nothing. So there's relatively high risk of getting nothing, and that justifies this high multiplier that they're arguing for. And all that being said, they're going to get their 11 million, and that's the end of that. So these firms do take on risk. Sometimes they go broke, but it's also a very lucrative line of work to be in. It's funny because people think of corporate law, right, or Bay Street type practices for big corporations and defendants as being highly lucrative, being highly prestigious. But if you're actually looking at dollars and cents, the best paid lawyers in Canada operate for plaintiffs. They work for plaintiffs on a contingency basis, either in the personal injury sphere or on class actions. So, okay, we're kind of running short on time, but this would be the top earners. That's right. Yeah. So I mean, there's some people who don't do as well in it, but a lot of them do well enough. Okay, so the next little piece in here was an interesting thing that just came up that raises an interesting debate, right? So I hope people have a chance to read this. You all hopefully know about the Sixties scoop, which was this practice of basically very aggressive behavior on the part of child welfare authorities with regard to Indigenous children in the 1950s, 60s, and 70s of taking children into care. So this article was written by George-Kanentiio, who was this happened to him, and there was a class action brought against the federal government and against various children's aid societies on the basis of this. And the class action received a quite generous settlement, many people thought, of $750 million. $1.3 billion was sought. But the thrust of this article is that the process of the class action deprived class members of any agency and basically kept them in the dark, right? So he says that they had, as class members, they had no input into the fees, they had no input into the approval of the settlement, and they were not, the process did not succeed in providing them with any of this information that they were interested in getting, right? So this is by design, right? This is kind of the way the Class Proceedings Act is written. It's written to empower the representative plaintiff and empower the class counsel firm to act on behalf of a large class. And that's the official policy reason behind that, is that, you know, that's what makes this economical, that's what makes this fast. That's what lets these claims be brought, even though individual damages might be quite small. But the argument here would be that, you know, at least with claims of this nature, it does not serve many of the other functions, many of the kind of reconciliation-related functions that you might hope for when you're talking about damages of this type, right? So with the residential schools settlement, they didn't just use class actions, they created a separate process, and people probably talked about this in Indigenous legal traditions or in other courses, but sometimes there'll be a special process which is designed to be more therapeutic and more participatory for class members. But the Class Proceedings Act we have right now is not that. And that's a debate we don't have time to get into, but I just wanted to flag it for you. Right. Okay. So I'm gonna go through this pretty quick. So it's topic 13B, right? So where are we? We've talked about class actions. This is what happened to the money, and I wanted to squeeze in this unit 13B because this course is supposed to be versatile, right? It's supposed to equip people, if at all possible, for many different types of civil litigation, and to practice in different jurisdictions and to practice in different types of civil disputes. And we've been following this conventional civil action, right? For the first half of the course, we did at least, right, where we went from pleadings to service motions, etc. And we teach this because something like this exists in almost every type of civil dispute, right? So if you go to Manitoba, if you go to Alabama, if you go to an administrative tribunal, if you go to small claims court, you're going to find something like all of this. I mean, the Americans don't have the cost of words, but generally, some things analogous to all these procedures will be found. Now, we've illustrated them through the rules of civil procedure, right? Because the rules of civil procedure are the most commonly used code. But I just want people to be aware that there's other codes out there as well. And I hope that, when you go into a niche civil litigation sphere, because it's all niches nowadays, right? No one will just be a civil litigator. You'll be a personal injury litigator, or you'll be a commercial litigator, or you'll be a family lawyer. I just hope that people are aware that there are special codes in all of these areas, and you need to be alert for the distinguishing features of them. And I want to just give you a few little examples of this. So family law is the most important, right? Because family law is the largest source of civil disputes in Canada. A full third of all the cases heard in Canadian civil courts are family law cases, right? So 1 out of every 3. And I know many people are taking family law, which is great, and hopefully you're learning a little bit about the procedure, family law procedure, in addition to the substance of family law. But the procedure of family law is different. Does that mean you're not learning the procedure? But it's different enough that there's a completely different code, right? We have family law rules, which, like the rules of civil procedure, are a regulation under the Courts of Justice Act. And the same basic steps are all there, right? So these conventional civil action steps are also going to be followed in family law, but there's also important differences. I give you a few excerpts from the family law rules here. Some of these things you'll find in the rules of civil procedure, the wording is just a little bit different. Some things are distinct, though, right? So this is something which is distinct in the family law rules: the duty to manage cases. The courts will promote the primary objective. Primary objective is dealing with cases justly, and the court's going to promote that through the active management of cases. So that means that the principle of party control is restricted even further in family law, in family court procedure, right? And judges are going to be more active than they would be under the rules of civil procedure in structuring the process and trying to make sure that it does justice in a proportionate, relatively quick way. More judicial intervention, right? So that means they're going to set timetables. We saw that with delay under the conventional civil action, it's still fairly hands off, right? Usually the parties have to, the defendant has to act if they want to kind of speed the plaintiff along. Not the case in family court. They're going to set timetables and move the case forward. They're going to help the parties to settle all or part of the case. So if you go to family court, you should be expecting the judge to wade into your case and act like an evaluative mediator, right? They'll do that in conventional civil actions as well, but it's more forceful in family court, right? There's settlement conferences in family. There's mandatory settlement conferences. You have to. It's kind of like mediation, but it's like an evaluative judicial mediation type procedure. And all of that reflects some of the realities of family law, right? The prevalence of self-represented litigants. The majority of litigants in our family courts are self-represented. So all the things that make civil actions so expensive are just backbreaking. If you have to spend $30,000 or $40,000 to assert your basic legal entitlements, like your entitlement to child and spousal support, your entitlement to a relationship with your child, your entitlement to live without fear of domestic violence, if you have to spend $30,000 or $40,000 to assert those things and you're a self-rep, then the whole system is pointless. So a lot of the family law rules are written to even more aggressively try to reduce the time and money cost involved in asserting rights. I gave you a little bit of this case, Frick versus Frick, which is basically a family law case in which some of the issues are the same things you'd find in normal civil procedure, in conventional civil procedure, in the sense that someone, the wife in this case, was put in these kind of like excessive and perhaps legally questionable claims or pleadings that weren't fully justified. The material facts necessary to ground her claim to this exceptional division of matrimonial family property were not there. But the defendant, the respondent, as they're known in family law, kind of threw away the family law rules and tried to proceed with the rules of civil procedure, right? And that a big takeaway from Frick versus Frick is that is not allowed, right? So paragraph 11, the family law rules enacted to reflect the fact that litigation in family law matters is different from civil litigation. The family rules provide for more active judicial case management, early, complete, and ongoing financial disclosure, and an emphasis on resolution, mediation, and ways to save time. They embody a philosophy peculiar to a lawsuit that involves a family. And so the point here is that these rules are real rules, and you can't throw them away and proceed under the normal civil rules of civil procedure when it's a family law matter. Okay, so this little 5-minute description has not equipped you, obviously, to practice family law, but I hope it has flagged the fact that these niches are different, and the rules will have subtle but important differences that you need to attend to if you're going to practice competently in these areas. Okay, so that's true of family law, but not only family law, right? The same thing is true of many other areas as well. So we talked about class actions. We've talked about, this is just a few examples of variations in civil procedure and things that will be different for you depending on what type of case you're dealing with. We did class actions already. Low dollar actions. Does anyone remember this? We looked at this when we talked about proportionality. What difference does it make if you're suing for less than $100,000 or less than $25,000 or $30,000? So the costs awards are still made with lower dollar actions. You can't have a jury. Juries can be restricted in those. The discovery phase, yes, an issue pertains to discovery. That's right. So we have something called simplified procedure. I think we had a slide on this back when we talked about proportionality. If you're suing for less than, it's now $100,000, basically discovery will be greatly curtailed because discovery is what drives up a lot of fees. And so to keep civil procedure proportionate when we're arguing over less than 100,000, discovery will be greatly curtailed. Don't need to know this for the exam, but I'm just flagging it is out there for you. And then if you go below $25,000, you're in small claims, where again, all the stages are still there, but everything is curtailed and restricted to try to create a mechanism of adjudication which can be used proportionately, which is not too expensive to be worth it for what they're talking about. Constitutional law, if you bring an action involving constitutional law claim, you have to give a notice of constitutional question, which basically means you have to tell the Attorney General, tell the government that you are challenging a law on constitutional grounds. There's a course in constitutional. Anyone taking that course this term or next term? Constitutional litigation. Recommend that if it's of interest to you. But that is basically just to say that when you're suing Joe Blow, but you're making a constitutional argument, like you're saying, this statute violates the charter, you have to let the government know, because the government has an interest in that, and they need the opportunity to send a representative to make submissions to the court about the constitutionality of the statute. Purely documentary cases, right? So cases where we're unlikely to have any need for oral evidence, we're unlikely to have to cross-examine anyone or do examinations for discovery. We have what's called an application. You bring an application instead of bringing an action. So there's some changes in the sense that there's no examination for discovery, and the documentary evidence is going to be appended to the application. So it basically becomes part of the pleading. Don't worry about this for the exam, but I just want you to know it's out there. Commercial bankruptcy. Here cases where some big corporation like Eaton's or was the most recent dramatic example, is going bankrupt. There is a consolidated practice direction concerning the commercial list. Commercial list is a special type of court that's conducted in Toronto just for commercial bankruptcy and similar cases, because there may be a lot of employees of that company. Right, and the company has to be restructured, and so the company is on the ropes. It's insolvent. It's going bankrupt. But there's a chance to rescue the company. Like maybe there's a foreign buyer who's going to come in and rescue Sears or Eaton's, right, and preserve those jobs. And if we're going to put that on the conventional civil action, it's going to take 2 years. Then the possibility of having that company rescued or restructured in a timely way becomes impossible. So we have this commercial list direction, which gets those cases heard really quickly and has much lower tolerance for any type of adjournment or delay on the part of the parties. And then finally, we talked about family law. So the takeaway from all this is that civil litigation is very diverse. I haven't even got into administrative civil procedure, right, where you're arguing before a tribunal. And there you have the Statutory Powers and Procedures Act. Hopefully you've talked about that in admin law. But anyway, the takeaway is it's diverse, and this course tries to give you a core which represents things that are going to happen in any type of civil procedure, but you need to have your antennae up when you go into different contexts and look for the things that are distinct in those. Okay. I think we can do disability and litigation guardianship in 15 minutes. Okay, so we are talking here in the second part of the course about restriction, like things that this cannot respond to, right? Circumstances that the conventional civil action can't deal with, and limitations to the conventional civil action. So one limitation is that this assumes that the parties can make decisions for themselves, right? We have the principle of party control. The parties defend their own interests. The process is not primarily controlled by the court. And it's also party control in the sense that the parties themselves, not their lawyers, make the most important decisions about whether to commence litigation, whether to settle, and whether to engage in different types, bring different types of motion. Lawyers have a duty of commitment to the client's cause, and that assumes the client is in a position to make those important decisions for themselves with the lawyer's advice. So what happens when all those assumptions fail, right? What happens when the party is not in a position to make those decisions? What happens is that we need another alternative route to justice, and that alternative route to justice is disability and guardianship law. Okay, so you have the basic rule here, which is Rule 1.03, that defines what a disability is. And this is, again, an example of a word that means one thing in normal English and means something quite different in the context of civil litigation. So what does it mean in civil litigation? It means a party is under a disability if they, first of all, are a minor under 18 years of age, if they are mentally incapable, or if they are absentees. So an absentee, there's a footnote there that defines that, basically means someone who has disappeared or whose whereabouts are unknown, even though they were previously a resident of Ontario. Okay, so all these people need this alternative justice, and this is what the participation question was about, right? So which of these people are parties under a disability? I tricked many of you with this one, right? Using a wheelchair does not make you a party under a disability, because that's no reason why you can't instruct the lawyer and make decisions in civil litigation like anyone else. This person cannot do so. She is not under a disability. She's left Ontario, but she is not an absentee. She's coming back. Reginald is a party under a disability. He's a minor. We don't, and so we don't let minors or expect minors to make these decisions. And Tarzan is also under a disability. He's an absentee within the definition we just discussed. Doesn't really depend why they're in a wheelchair. I mean, this is mental incapacity, right? There's no reason to believe a person in a wheelchair would be mentally incapable. Okay, so what does this mean? If you're under a disability, Rule 7.01 says that a proceeding for a party under a disability, the coma is yes, person in a coma is under a disability. Yeah, because the person under a coma is mentally incapable to make these decisions. Okay, so you need a litigation guardian. Any action, any litigation has to be conducted by a litigation guardian. So what is a litigation guardian? A litigation guardian is a person who is not under a disability, which is to say a litigation guardian has to be a mentally competent, non-absentee adult who is going to act in litigation on behalf of someone who is under a disability. Very often a litigation guardian will be a close relative. In the case of a minor, it will usually be a parent, or in the case of an older person who may have Alzheimer's or something like that, it will often be an adult child of that person. And they are going to, if there's a statement of claim that has to be issued on that person's behalf or a statement of defense, it's going to be their name on that statement, on that pleading, saying, name litigation guardian of the person under the disability. Okay, so a couple of important points about litigation guardianship. Number one, you do not need a court order to become a litigation guardian, right? So, if if a parent or a grandparent of yours is under a disability, you can basically start a lawsuit on their behalf if they have suffered some wrong. And your pleading says, I commence this proceeding in my capacity as litigation guardian of, insert the name of your parent there. And then you bring it to court and you bring a motion to confirm it, right? So you can basically sort of provisionally decide you're going to be litigation guardian for yourself, and then the court will decide later whether to confirm you in it. But typically they will, unless someone says you shouldn't be litigation guardian for some reason pertaining to conflict of interest and so forth. Or if that nominally the person who you claim is under a disability says, hey, I'm not under a disability, I'm right here and I'm mentally capable, then there will be a motion to determine whether or not that is the case. If it is the case, then you cannot be their litigation guardian. Okay, so a second important point about litigation guardianships is that the litigation guardian cannot be the person's lawyer. the lawyer for the party under disability and the litigation guardian have to be two separate people, because the litigation guardian's role is to instruct the lawyer. And this is counterintuitive to many people, right? Because many people will say, well, you're my lawyer, or you're my mom's lawyer. My mom has Alzheimer's, and why don't you just decide what to do to protect her interests? And you have to say no if they say that to you, because it's a very important principle of legal ethics that we as lawyers are not supposed to make these important decisions in litigation on behalf of our clients. We're supposed to act on our clients' instructions, right? We're not best interest guardians of our clients. The clients make the decisions, we counsel them, and then they make the decision. So if the client is under a disability, which is to say unable to make those decisions on their behalf, we don't take over the rowboat, right? Rather, we have the litigation guardian instruct the client on their behalf. Okay. And this rule of professional conduct reflects that, right? Where a client's ability to make decisions is impaired because of minority, mental disability, or for some other reason, the lawyer shall, as far as reasonably possible, maintain a normal lawyer and client relationship. And the presence of the litigation guardian is what makes that possible. Okay, so the litigation guardian under Rule 7.05, they do anything that's required by the party in that litigation, right? Including authorizing the motions, preparing the pleadings, and so forth. A litigation guardian shall diligently attend to the interests of the party under disability and take all steps necessary for the protection of those interests. And one thing they cannot do, a litigation guardian cannot do, is unilaterally decide, accept, or make a settlement offer. Right? They can settle the case. Litigation guardian can settle the case on behalf of the incapable person, the party under disability, but only provisionally, because Rule 7.08 tells us that settlement approval is again required, right? Just like with class actions. The court has to approve any settlements. 49.08 reinforces that. So this again is to protect the interests of the incapable person, because of the risk of a conflict of interest between the litigation guardian and that incapable person. We're going to trust this litigation guardian to make these decisions, but we're going to have an extra check where the court is going to look over that settlement and decide whether it really is a reasonable way to protect the interests of the party under a disability. Okay, so Limbani. Limbani is a case that tells us about what a disability is, right, and helps us interpret Rule 1.03. So the case involves a somewhat confusing family tree. At the core of it is this lady, Pushpa Limbani, who was born in Uganda and came to Canada in the early 1970s with her husband. And she had two children here in Canada, Satish and Harish. The husband unfortunately died in a car accident in 1979. Okay, so her two sons, Satish and Harish, are in a dispute over real estate. We don't know what it's about, it doesn't really matter. But this real estate is held in Pushpa's name, right? So Pushpa is on title to this real estate, but her two sons are arguing over it. Satish says that Harish, the elder one, is damaging mom's interests, right? So he's not protecting this real estate, or she's suffering some loss as the result of what Harish is doing with the real estate. So says Satish. So Satish says, okay, I'm now going to be mom's litigation guardian, right? Remember, no court order is necessary. You can basically provisionally appoint yourself as litigation guardian and issue a statement of claim on behalf of someone who you say is under a disability. So he advances this claim. Harish brings a motion saying, wait a minute, she's not under a disability, and if she's not under a disability, then the whole claim is thrown out immediately, right? Because he can't be a litigation guardian if she's not actually under a disability. Okay, so let's go back to our three options. Under which of these three bases does Satish say that mom is under a disability? Mentally incapable. Yeah, that's right. So his evidence for this is found in paragraph 7. And he says basically she doesn't speak English. She comes from a very patriarchal culture in which women, or at least married women, are not expected to make decisions for themselves. That's according to his evidence, the culture is such that the husband or the eldest son is going to make those decisions. She is not particularly educated. She doesn't understand the legal system in Canada. And she knows a little bit of English, but not much. She certainly wouldn't, understand legal terms in English. She's never worked outside of the house, and she has some medical issues, right? Diabetes, hypertension, and heart disease. Therefore, they argue she is incapable of making informed and correct decisions. Okay, so starting a lawsuit is always intimidating for people, right? And here, the alleged wrongdoer is, in fact, her son, right? So Satish, the younger son, says, can we really expect her to stand up and advance this claim against her own son? And given all these cultural factors, isn't she a party under a disability? So that evidence is there, but they, on the other hand, it's said that she's very alert and she's quite healthy mentally, and she's certainly not, in a coma or have any sense, nor is there any evidence of any mental health problems, right? Or like Alzheimer's or anything like that. Okay, seems like a clear majority say that she is not under disability, which is in fact what the court says, right? The plaintiff has not met this test. She's healthy mentally. She's stable mentally. She's not a disabled person within the meaning of the rules. So the case is an important reminder that litigation guardianship and this idea of being under a disability is potentially dangerous because we're talking about depriving people of their agency. It might have looked a bit different if this were not a dispute within a family. Like if the defendant were a corporation or someone outside of the family, it might look a bit different. But it's also important to remember that even if someone is not under a disability, if they're not experienced with the law, then they will very often draw on resources from within the family, right? So my wife does estate litigation, and it's quite common so those are typically legally inexperienced siblings who are in a dispute over a parent's will or incapacity issues. And it's very common to come in with a friend or with a spouse or with someone who can kind of help you out if you're all on the same page. Right. Yeah, that's well said. Right. That arguably the disability system, if this whole concept could have reinforced the very patriarchy which is being used to justify the claim that she was under a disability. Okay, so we're over time, but thank you very much for bearing with me. and I'll look forward to seeing you on Tuesday, and drop me a note if I can help with anything. Have a great weekend.